Yes, good evening to the participants of the SLW-670. Karibu sana, welcome to our class. And today that I am going to deal with the virtual class on the topic intellectual property and entrepreneurship. This is the topic that which I am going to make it out. And if you happen to see the syllabus, you could see on the screen, it is clearly mentioned, the syllabus is. And it says 2.2 general issues in intellectual property. That is, small bullet is intellectual property and entrepreneurship. And in all other classes that we dealt the 2.1 legal framework, total small bullet 0 and small bullet 0, and that is the influence of the TRIPS agreement. The second one is the multiple legal frameworks, international, regional, national, the efficacy and the role of the REPO. And in this class that we are going to deal this intellectual property and entrepreneurship. So without wasting the time, let me come to our point is concerned. Participants, are you hearing me? Yes, unmute can say that so that I could think that you are with me and I am with you. Both are in the same bus or the car traveling to the same destination. Yes, that I already posted it in advance. That today class is that I am going to take it from 9 p.m. to 9:50 p.m. And now that already the time is up, it is 9:03. So without wasting the times, let us go to the 6 steps for the entrepreneurs to approach the intellectual property rights. So now many artists, web designers, writers, and musicians start jointly collaborating without a clear understanding of the importance of the intellectual property. So first you should understand what is the intellectual property. It is the property of the brain. So a person who has developed such a property with the brain and he wants to have the control over it so that nobody would exploit it without paying something to him because he is the person who has developed that property by his own intellectual brain. So in fact, many entrepreneurs fail to realize that the IP, that is intellectual property for their businesses, may be their only fundable asset. So they did not have a knowledge that even a logo you cannot supposed to use it, somebody's logo, if it is patented, if it is registered. Hence, it is extremely important for the future graduates to be educated about the IP, not only the graduates and the practitioners also, and for the potential entrepreneurs to be made more aware of the need to properly identify and protect the IP rights. So when a person has made such a new products, a new intellectual property that he has made it, then naturally that he would like to see that something should be in cash for his livelihood also. So the law will protect them in the entire world. So the case center and the Asset Entrepreneurship Institute, there is one of the institute is there, EEI, Asset Entrepreneurship Institute. The EEI use the initialism, recently published a new case titled Gunnos. That is one of the case law. Rather we can see it. What is Gunnos? Aiming at the digital comics, authored by the senior lecturer Constance Lutoff and Carol, with the editing the Suzanne Jenkins EEI case developer. So now courtesy to them that I have to tap this information from them, and hence I should endorse, otherwise it leads to the plagiarism. The case is about the creative artist and writer Tom Carroll, that is a nose gun, and who is at the very earliest stage of the starting up a business with a loose consortium of the graphics designer who hope to capitalize on the growing trends of the digital comics. So he is one of the comic writer and he develops the graphics. And the case was developed by the MBA student and executive wrestling with the digital disruptions in the publishing media and entertainment industry, and offers 6 handy steps to approach the intellectual property rights. With the notion of the gun nose, which is developed by the graphicers and for the MBA students, and he made it, there are 6 steps for the entrepreneurship in the intellectual properties. Now let us see that how we can make it out. Number 1, identify. Number 2, protect. Number 3, allocate. And number 4, monetize the intellectual property rights. Number 5, structure the terms and conditions of the licensing contract among the collaborators. And if necessary, if you want to get the collaborators should be there for gaining the capital. Yes, you can do so. You can give the copyright to them and the royalty that you are going to get it. The 6, pursue the enforcement against the infringers. Suppose somebody has, without your consent, used that, and you can have every right to tap the court door so that you will be compensated, because it is the intellectual property of your own, which is designed over there in the business or entrepreneurship, that should not be exploited by the other without having any consideration with you. Now let us see the step 1. Identify the type of the intellectual property rights to be protected in the relevant jurisdiction. So what are the intellectual property rights would be there in the particular jurisdiction that we have to identify it. So number 1, that is the step 1. The main type of the IP, intellectual property of these, number 1, copyright. Number 2, trademarks. Number 3, patents. Number 4, trade secrets. Of course, there are geographical areas also be there, and designs also be there, and we will see, but it comes out of among the 4 only, if you broadly divide it. Copyright law protects the original creative expression, meaning authors and artists cannot copy the reproduce the unoriginal portion and claim them as their own. Copyright does not protect the abstract concepts and the idea in your work, only the author's way of expressing these ideas. Suppose if he is using somebody's ideas, at that instance, you have to acknowledge in the reference. Without acknowledging it, leads to the plagiarism. Even though the idea is taken from him or her, but even if paraphrasing it, but the idea belongs to him or her, and hence you should have to make it a footnote, and there you have to cite the citation of him, otherwise it leads to the plagiarism. Then the next comes that trademark is concerned. Trademark laws protect the use of words, slogans, symbols, colors, sounds, product designs, and product packaging, and consumer recognize the identifying the business or its products or services, or both that distinguish them from the competitors. And the Puma shoes are there. And when you see the Puma shoes, I believe that the Jaguar is there, which is jumping over it, if I am not mistaken. Or we can say cat also. The cat is jumping over there in the Puma shoes. But the Nike is concerned, the slogan, not slogan, the symbol is right. And you have to see in the Pepsi. In the Pepsi, the trademark is there. Even a Coca-Cola, it is having the trademark. So every product which is having their own trademark, and if anybody copies it, it is the infringement of the trademark, and they will be punished as per the law is concerned if anybody taps the door of the court. In the US, patents are only granted for the inventions that are novel and not obvious to a person skilled in the art of inventions. In the EU, they say a patent can be granted for any inventions having a technical character, provided that it is a new and involves an inventive step and industrial application. So patents are there, the new inventions are there, like a basmati rice. Yes, a new invention would be there, the basmati rice, but only few of them is got the trademark. Others will not get the trademark. And especially when it comes to the basmati rice, and the first and foremost we can say the Pakistani, but the Indians got only 3 varieties of the Pakistani basmati rice, and that you can see in the Google if you search it. A patent covers the how things work, what they do, what they are made, and how they are made. So these are the things would be there in the patents as concerned. And the design is concerned, the design patents provide the legal protection to the ornamental design of the functional or utilitarian item under the US laws. Or a design patent protects the iconic shape of the Coca-Cola bottle. Yes, that I told you the design, and the EU recognize the similar concept known as the community design rights to protect the visual design of the industrial object which have the aesthetic value. Even the United Nations organization is having its own logo, and that logo cannot be copied or taken by any other thing. And you would have seen the logo already. Trade secret laws protect the confidential and proprietary business information. Business information may include the formulas like a Coca-Cola famous recipe is protected as a trade secret and they never reveal it to it. Now that's why they are not patented it. When you want to patent it, they have to reveal it. Later part. So the policies, the practices and processes, designs and instruments are patterns. So some of the product, they don't reveal its combinations, it's the equation, it's the composition also. So that is the number one step is concerned. Step two is protect the various type of the IP rights identified. So what are the IP rights? Intellectual property rights should be identified, should be protected. So when you see that copyright is inherent to the creation of the work because it's a literary work or a sculpture, and thus if you have an author write down your original ideas on paper, they are automatically copyrighted without having to do anything else. But generally, when you are writing the thesis or when you are writing the dissertation, that you can use the copyright column in the preliminary pages where you can mention the Berne Convention. I don't know whether you know it or not. Please check it in your LLB, check in your LLM, and check in your PhD. There is a copyright one page is there where you can mention that the Berne Convention, and this is my original work and not submitted to anybody, and if anybody wants to use it, let them use it by the permission of the author, and where it is submitted, for instance, if it is submitted the South permission should be taken. So that is the thing which is made it very much clear in the copyright is concerned. To show ownership, the convention is to add the phrase copyright, that is its symbol is a circle, within it C is written over there. C stands for copyright. The C here and your name to the work. The further protect your work, you should register it with a copyright office in your local country. So that depends upon your local country, that if you want to see that nobody should have to use it, means you try to register it. And this allows the better enforcement if someone infringes upon your copyright. So if somebody infringes the copyright would be there. If it is not registered over there, then there is a less possibility would be there that it is not registered you, and hence one can be used because it is there in the public domain. So the trademark owners establish the right to the trademark once it is put in use, but the rights are limited and apply only to the geographic area where the business is providing its goods and services, and for national rights. For instance, you take the Voda. It is having its own trademark, a logo, and the same in the way Airtel. And one should not copy it the same. Otherwise, if you copy it and make it out, then it is an infringement of the rights. So for national rights, one needs to apply to the country's trademark office to register the trademark. And a registered trademark provides the broader and stronger protection than an unregistered trademark. So generally, when a trademark would be there, it should be registered in the local area where they are hailing from. Of course, in every country there is a office should be there where you can register it. To obtain the patent, the inventor must file a patent application with the patent office. The rule is first file for obtaining the patent and patent protection, and not for to invent it. So if any new thing is invented over there, then naturally you should be patented. Like I told you, the basmati rice or neem tree, and a neem tree that we will say the Imti Arbaini in Swahili. So naturally that Imti Arbaini, it is from India, but USA has patented it because there also the Imti Arbaini, that is the neem tree, will be available over there or exist over there or grown over there. So design rights in the using EU may be unregistered or registered. Both the things would be there. But when you register it, you have the claim. And when you unregistered this, somebody would like to tap it and they will copy it and they will violate it, and there you don't have any right to file a case against him because it is unregistered. As with the trademarks, stronger and broader protection is conferred by registration. As I told you that already, that if your trademark should be somebody is using it, then without the registration, you cannot bring an action against him or her, and hence every trademark or patent you should be registered in the local area where it is invented or made or bring to the notice of your new inventions. So design patents must be applied with the US Patent and Trademark Offices. Either the US Patent Offices or the Tanzania Patent Offices or India Patent Offices or Kenya Patent Offices. In every country there is a patent offices are there and the trademark registration is there. One should have to register in that place where that held from that country. So participants, are you there? I don't know, Timothy Chakoti, are you hearing me? Unmute and say, sir, I am hearing you. Timothy Chakoti, are you there? Do you know how to mute and unmute? Are you a student of SLW-670? Please speak. If you don't speak, then my 3 stanzas are there. My tongue is tied, my hands are handcuffed, my legs are fettered. I don't know whether you know it or not. Do you know it? Timothy, do you know it?
Yes.
What is that?
That means.
What is that 3 stanzas?
That
Posted
means.
on the screen. Read.
I think there's something interrupting.
What is interruption? Are you a student of SLW-670?
Yes.
But I never saw you. I never saw your name.
Yeah.
Chikoti, could you see my screen?
Yes, I see you on the screen.
Read what is posted there.
So what I see, my hand are handcuffed.
What about this one?
What?
Where I am moving the cursor.
My tongue is tired.
My tongue is tied. What is this cursor? Read.
My hands are handcuffed.
Then read.
My hands are handcuffed.
The chini, where I am moving the cursor.
My legs are fettered.
You know what is meant by fettered?
I don't know.
See, I have shown you there the photo.
Okay, yes.
There is an image is there. A chain is close together tied.
Yes.
So that you cannot make a free walk. Either you have to slowly step it or you have to jump it.
Oh.
If you don't give the answer, my tongue is tied, my hands are handcuffed, my legs are fettered, I cannot move further.
Okay.
That is my intention. Is it clear?
Okay, I understand. Yes, I understand, sir.
Yeah, without an answer, I cannot move it. I want to get the answer from you, either yes or no, or pass on, whatever it may be. So now we are at this stage, step 3. Can you read what is the step 3? Here I am showing the cursor.
Yes.
Highlighted it also.
Allocate the rights. Once the various intellectual property types and rights have been identified and protected, then the entrepreneur needs to decide how to allocate or apportions the creative rights amongst the team members. This step goes hand in hand with the next step on commercializing the rights.
Yes. The explanation is once the various IP types and rights have been identified, and they should be protected. For the protection, the entrepreneur needs to decide how to allocate, apportion the creative rights among the team members. Which part of it should be protected? And if it is protected also, it is for not the lifelong. There is a duration would be there for the protection. And after the duration expires, roughly 20 years. Then sometimes the product's 10 years. Then it becomes a public domain. If a new product would be comes out of for that old one, then it can be protected. So these steps goes hand in hand with next step on the commercializing right. What is the next step with the commercializing right? It depends upon the how much the production that one should have to get it, number one. Number two, it also says if the time period is over, the production will not be available. So that is depends upon the entrepreneurship is given. For not the lifetime, even when you are having the copyright also, there is a limitation is there. What are the limitation? They said either the 70 years or till the death, something was made. It depends upon the country to country and where the copyright act is passed or promulgated, and they will make the duration. So step 4 is concerned monetize intellectual property right. The most common way to monetize the IP rights is by licensing them. How do you get money? For instance, if you want to drive a car, what do you need it? Tell me.
Driving license.
Who will issue?
When you want to drive a motor vehicle, first you must have a driving license.
Who will issue? President will issue. Prime Minister will issue. A member of parliament will issue. Or TRI issue. Which is the body will issue the license in Tanzania? Did you understand my question?
Not yet.
Do you have motorbike? Do you have a cycle? Do you have the four-wheeler? What do you have? Sir, I don't have anything.
I don't understand the questions.
What transport do you have?
Transport do you have? I have a motor vehicle.
Motorbike.
Yes.
Did you have the license?
Yes, I have the license.
Who issued the license to you?
From TRI.
For everything is TRI.
Examination from the police officer.
There is a body is there, a organization is there, a corporation is there, a institution is there, they will issue the licenses. What type of license you have?
I have Class D and Class E.
Means can you drive the lorry?
Yeah.
A truck?
For Class D, I can drive all saloon cars. And the Class D, all passengers.
16 tires. 16 tires truck can you drive?
What?
Kumina Sita tire.
Yes, for class E I can drive it.
Kumina sitta tire.
Yes, for class E I can drive it.
There is a different, and you will get it the free of cost. You have to pay the license fee.
What?
Do you have to get the free of cost from the government, or you have to pay the license
No,
fee?
no. Yeah. I have to pay. You always when you need driver license, you have to pay 7,000 shillings
It is for the
to the
life.
government. To the government.
Is it for the life?
Is what?
The validity is for the life.
Yeah, no. It is valid for 5 years. Then after 5 years, you renew it.
This is the point here I want to make it out. Monetize the intellectual property rights. Get the money. The most common way to monetize intellectual property right is by licensing them. You have to give the license to them. When you give the
Yes.
license, and you will get the money. So a license is like a rental contract. The licensor owns the IP and rent it to out the licensee, normally in the exchange for an upfront fee and a royalty percentage contingent on the sales, either gross or net. And if I wrote the 2 books in Tanzania under the joint authorship.
Which
And
book?
I made a contract with the Law Africa. Do you know what is Law Africa?
What is?
Law Africa. LAW Law space Africa. AFRICA.
Okay, I understand,
What is
but I
that?
don't know it. I don't understand.
You don't know what is Law Africa?
Yes.
I will show you what is Law Africa here. Did you see now Law Africa?
Yes.
What is that?
We are. It's Mr. Law Africa. Law Africa. Hey, law about Law Africa, having been in the business for 2 decades, the firm has have affordable relationship with leading suppliers of law materials with long-term experience in both in both print and electronic publishing.
What it means by
And
Law Africa now?
so what?
What is meant by Law Africa now?
Now it means it dealing with
It
print
is a
publishing material.
publisher. Publish the
Yes.
books, publish the journals, publish the reports.
Yes.
Mukuki Nyota. Najua.
Yes, I know.
What is that?
It is publisher also.
So whenever you have a contract with the publisher, Law Africa, there is a percentage would be there on the sale because I am the intellectual property writer of the author and I will give the rights to the publisher to publish it and they will give us depending upon the contract 10 or 20% and that is called monetizing. Is it clear?
What? Oh, yes.
That is called monetizing and taking the money from them and giving the license to them. So, this is my book written by me and another Atuman Mage, the local man.
Which book?
Yeah, here you could see it. General
General
Principle of Contract in Tanzania.
Okay, of contract.
Did you read it?
So I have to find it and read it.
Read, what is that?
General Principle of Law of Contract in Tanzania.
Written by
Mohammed Saheb Hussain.
Proceed.
Mohammed Saheb Hussain. Muhadhal
Mudhir Atman
Osman
Magi.
McGee.
Yes. So why I am showing this one is it is my brain and I produce the book with Magi and I can monetize it by licensing them to publish it. And they will give the royalty. So a license is like a rental contract. The licensor owns the IP and rents it out to the licensee, normally in the exchange of an upfront fee and royalty percentage contingent on the sales, either gross sale or net sale. For every year we will get the royalty on the sale, 20%. So we are the two authors, since either 10% or 5% will share together. So therefore, a key problem for the startup team is to figure out who owns what right and who deserves what percentage of the upfront license fee and royalties. So it is the Law Africa and myself and my author will make a contract, how much the percentage would be there on the sale every year. But do you know that they will say that we will publish only the 500 copies, even they may publish 100,000 copies also. So we will trust each other. Is it clear?
Yes.
So my another book is there, Law Africa Publishers, that is law relating to the child in the East Africa. And if you type it, the law relating child in the East Africa, published by me and Dr. Clement Mashamba. Once upon a time, he is the attorney. Have you heard the name?
Dr. Clement.
Clement Mashamba.
Okay.
So he is my PhD student. I was the supervisor in the Open University of Tanzania, and we wrote the book. So there is a royalty would be there, and it is my property, intellectual property, hence I can give the license to them in the form of royalty. Steps 5 is concerned, structure the terms and condition of the licensing contract among the collaborators. So either in the gun nose case, either in the gun nose case or the Law Africa contract, the protagonist not dealt properly with the issue raised in our framework so far. This complicated any effort to structure the licensing contract and a potential comic problems. So naturally, then when you have the contract with the publisher or the contract with any other organization, and you have to keep the conditions, and the condition should be fulfilled. If anybody violates the condition, then we can tap the door of the court. So the key message is to get those written contracts in place earlier than the later. So now every terms and conditions should be put it in writing. So we sign the two types of the contract. One to publish it, one to for the royalty with the Law Africa. Of course, if you publish it, the Mukuki Nyota also, there is a contract will be there. And they will not take a single pie from you, but they will publish it and they will give the royalty per month, per year. Is it clear?
Yes.
Yes, still 5 minutes are there. Now step 6. Pursue the enforcement against the infringer. Suppose somebody used your property or copied the entire one chapter, excuse me, and used it in his own book without the permission of the author or the publisher. then we can file a case against him under the Copyright Act. So if IP rights must be enforced against the infringer, bear in mind that merely owning the IP right does not prevent someone else from misusing it. The entrepreneur needs to seek proper legal advice to stop the infringer. So whenever you are using anybody's excerpts, excerpts, or a passage or an idea, you have to endorse it in your footnote, otherwise it leads to the plagiarism, and which is an offense. But if you are using for the notes purposes, not for the commercial purposes, at the time you need not to take the permission of the owner of the property or the author, because you are not doing the commercial function, you are doing only the service to the students. Did you get my point?
Yes.
So at that time you have to make it out. Otherwise, it leads to the plagiarism. So what I want to say is, whatever your invention is there, your patent is there, your brain work is there, your intellectual property is there, you should be protected. The law relating to the child in East Africa. This is also written by me and Clement Mashamba. Let me see whether it is there or not. Hussain Muhammad, it is there. Did you see it here? Mashamba Clement J. Wildcat Identities, Child Rights and the Law in East Africa by Mohammed Saheb Hussain book, third editions, published in 2015 English, held by the Wildcat Member Library. Even I have given the book to the library also. Here UDM library I have given, and the South library I have given, and the Ruku library I have given, too many, that is the University of Iringa I have given, Mzumbe University I have given, Morogoro Muslim University I have given, University of Bagamoyo I have given. So as a complimentary copy to those people, those who wants to make it out. Is it clear from the screen?
Yes.
The another book is also there, Understanding the Law, Question and Answer series, that is Matokia Publishers. And that book also there. And as I told you that I'm not blowing my pipe, I became the professor in the University of Dar es Salaam when I was working. I am not the professor from India. I am a professor from Tanzania, East Africa.
Okay.
So a lot of my services are done in the Tanzania from 2004 to 2015. Even I am the external examiner in the South. Several times I came over here to value the question papers, to value the master's dissertations. So now my point is here, and you only one student are present today, but another student, I don't know what happened to him, and he promised that, sir, you take the class instead of 5 o'clock, you take the class later on. But I told them, I have another engagement, but I will take the class at the 9 o'clock to 9:50. Even that person is disappeared. Do you know who is that person?
I think he's Mnyeke.
What is his name?
Mnyeke. I know for the one name, Mnyeke. Yeah, I think we are a few students on this subject.
Well, a few means what? 1 or 2 or 3?
I think almost we are, those are active almost are 3.
But can you find them their email or mobile or WhatsApp and send to me to my email? And you know my email.
I don't know your email.
Dumisha uhuru na umoja.